Welcome to Behind the Scenes at Andrew Pickett Law, bringing excellence, compassion, and relentless advocacy to life's toughest moments. From car accidents to insurance battles, we guide, support, and advocate for you every step of the way.
My name is Andrew Pickett. I'm the owner of Andrew Pickett Law here in Melbourne, Florida. We specialize in personal injury and auto accident cases. I am here with my marketing coordinator, Allison, today to talk about preparing cases as if they're going to trial.
Thanks for having me.
You're welcome. Thanks for being here.
Thank you. So how about you start out with telling me why you believe in being trial ready?
I think that the insurance companies are aware of which firms go to trial and which firms do not. And we want to be ready in every single case that we could possibly go to trial, because you never know at the outset how a case is going to develop. And if you take shortcuts early on in the investigation and you miss gathering key evidence, but then later you have to file a lawsuit and go to trial, you lose that evidence forever. So we want to be ready in every case that we could potentially be going to trial on so that we can preserve the ability to prosecute the case to the fullest.
Okay, so let's take everyone behind the scenes a little bit. And what does trial preparation look like step by step behind the scenes?
Well, that's a pretty involved question, but as it relates to the early stages, what we're doing in the investigation is gathering information. So we're identifying witnesses. We're making sure that our investigators interview anybody who may be a witness to the accident. We're interviewing the police officers. We're getting photographs of the scene. A lot of times we can obtain surveillance footage from nearby businesses. We can get recordings from 911 operators for people who are calling in. We can get body cam footage from police officers.
Is that something that, I'm sorry, I didn't mean to cut you off, but is that something that you could get if you didn't hire an attorney?
You technically could, but it would take a lot of work. And part of it is knowing what to look for and having the contacts to get that. So we have a pretty standardized process for gathering information at the outset that we do when we assign a case to an investigator so they can gather all that information. That becomes helpful for trial later on, because if there's a dispute about who is at fault or liability or the severity of the impact, a lot of times that early evidence gathering will help to substantiate that. So that is one step in the early trial process, is just taking an inventory of all the investigation that we have so that we can be very clear on who the witnesses are. Because if we don't identify that at the outset, it's really hard to reconstruct that, years down the road.
So you talked earlier about how insurance companies know which firms go to trial and which don't. How does this approach change the way insurance companies communicate with us or even negotiate?
There are a couple of distinctions that I think can be separated out. One is how insurance companies treat somebody without an attorney versus with an attorney, and then how insurance companies treat somebody who's represented by an attorney who doesn't go to trial versus one that does. And so with the difference between somebody who's not represented by an attorney and somebody who is, if somebody's not represented by the attorney, then the insurance companies will try to take advantage of them by trying to settle early on, undervaluing their case, because they know that that person will never be able to file a lawsuit or take the case to trial. There's something similar going on when they're evaluating the law firm that represents the client. If they know that a law firm never takes a case to trial, never files a lawsuit, then they know they can get away with offering a lower amount because there's no risk to them. Whereas when the insurance company deals with a law firm that regularly files lawsuits, that takes cases to trial, they know that their risk is that if they take the case to trial, they could be on the hook for a lot more than they're offering before that point. So it creates a lot of risk, a lot of exposure for the insurance company if they know that who they're dealing with is going to hit them for a big verdict. And so that's what we try to do with our preparation, is we want to communicate that we're willing to take the case to trial if we need to. And we take a lot of cases to trial and we get results that are much better than the insurance company makes the offer of before trial.
So speaking of results, how does being trial ready lead to better results for clients? Do you have any direct examples of it too?
Yeah, so I think a lot of what you can see in the typical case is that during the pre-litigation or pre-suit phase, when you're negotiating with the insurance company, they're usually offering a lot less than they do once you file a lawsuit. And then once you file a lawsuit, they might offer more money, but then they're going to offer more if they know you're going to trial. So a case might have a pre-suit settlement offer of $30,000, and then you file a lawsuit, it gets up to $100,000, and then when you get to trial, they might be offering $500,000 the week before trial. It could really be that dramatic, and that's not going to be every case, but usually we're going to see a progression in the settlement offers as the risk increases. So the closer they get to trial, the more they're going to be willing to pay to settle the case, and so that's why it's important to have a law firm that's actually willing to go, because if you're being represented by a firm that doesn't really go to trial, then the insurance company can call their bluff.
How would somebody know which type of firms are going to trial and which type of firms just don't go to trial?
So I think that understanding their results, particularly their verdicts, is influential in that. A lot of law firms will advertise their verdicts through their website. I think a lot of other attorneys and judges can be good sources of that information. A lot of the local community knows which firms go to trial and which ones don't. So I think that looking at their past results, speaking with attorneys and judges in the community, those can all be good ways to figure that out.
And so, why do you think clients deserve this level of preparation, even if the case never goes to trial?
Because you just never know how big a case is at the outset. And if a client is coming to a lawyer in a time of need, they're counting on that lawyer to do the best they can for them. And really, the only way to do the best you can for a client is to have that threat of a potential trial. And so, any law firm that doesn't have the preparation and the willingness to go to trial is underserving their clients because they're undersettling their cases.
So, let's give a little education into what it would look like. What does that timeline look like if I get in a car accident and my case does go to trial? How long could it be for me?
Well, that can vary widely. So, what we're typically looking at is each case, really every case, we try to settle it if we can. But that's only if we can get a fair settlement offer. And what we're seeing increasingly, especially in the past few years, is that the insurance companies are undervaluing cases. And especially in the pre-litigation process, they're offering a lot less than they did even a few years ago. And so the pre-litigation process itself, where we try to settle without a lawsuit, can usually take anywhere from 6 months to a year. And then once we file a lawsuit, we're usually not getting a trial date for another 18 months. So it can be a while before you get to trial. But most cases do settle without having to go to trial. So you're not having to wait years and years on every single case. But it does require a lot of patience, especially if you want to get the maximum result in your case.
So, what does it look like during the client journey? If I'm in a car accident and I hire Andrew Pickett Law, and then at some point in time, the best advice is to file a lawsuit. What does that look like for me? What do I need to know in that process? Do you guys make those decisions?
Well, the decision about whether to file a lawsuit is a decision that only the client can make. So we give advice or recommendations along the way, but the client has to be comfortable with it. Because once we file a lawsuit, there is significantly more work involved, both for the law firm and for the client. The fees increase from 33.3% to 40%. Our costs start to increase a lot. We're spending more money on experts. It can take a lot longer. But the upside is that ultimately the hope is that we can recover more money for the client and get more of a fair resolution. So that is a client decision that is guided by an attorney recommendation.
Okay. So going back to our core values, like what does relentless advocacy mean to you in your work in personal injury?
So kind of as we've been discussing, the process of being willing to file a lawsuit and being willing to go to trial is, I think, a very good illustration of our relentlessness in the pursuit of the maximum compensation possible. We don't just take the first settlement offer that is being made, and we don't take no for an answer from the insurance company as well. And so we do whatever it takes to create that risk that gives our clients the best result possible. And when I say creating risk, I mean we're creating risk for the insurance company, that if they take the case to trial, they're going to get hit for a verdict that is much more than what they're offering at the outset.
Do you have any direct examples of like the difference financially between cases that don't go to trial and cases that do go to trial?
Yeah, in just about every case, you're going to see a significantly higher settlement offer at different stages. So one stage is at the pre-litigation stage where you haven't filed a lawsuit yet. You're usually going to see the lowest offer there. Then once you get into litigation, you might go to a mediation and you see a higher offer there. And then as the case gets closer to trial, you're going to see even higher offer. Most of the trials that we do, we're seeing jury verdicts that are multiples higher than they ever made either during pre-litigation or in litigation. And we try to be very selective about which cases we take to trial, so that we know that if we're taking a case to trial, we have a reasonable likelihood of a good result in that case. So it justifies the risk that we're taking, not only for ourselves, but also for the client.
Okay, so closing back in on like our core values to close this one out, like how does the approach of relentless advocacy reflect the firm's promise of like excellence and compassion in every case that we take?
So we really try to treat all of our cases as if it were our only case that we have. And what I mean by that is that our clients are not just a number among hundreds of cases. Each person means something to us. And so we try to be compassionate at the beginning of the process and throughout the whole litigation. And so we carry that compassion from that initial phone call all the way up until trial. And we really place a lot of emphasis on becoming better and better at our craft, which is trying cases. And we use that continuous development to become excellent trial attorneys. And our whole approach and not giving up along the way is how we exhibit our relentlessness. And even at trial, we're making sure that we are much more prepared than the other side so that whatever the jury ends up doing, we know that we've done everything that we can.
To give everyone like an example, so like say a case goes to trial and we're in it for like a couple of years, like are you still like personal or professional friends with, clients that you've helped in the past? Like imagine what can happen in a 2-year or 3-year time span.
Yeah, and sometimes even longer. So I think that the litigation cases, especially the ones that go to trial, are the ones where we get to know our clients the best. And we're spending a lot of time with them in the preparation and the whole journey. It's almost like they're a member of our family or a close friend. And so most of my clients whose cases I've taken to trial, I've maintained communication with and even friendships with over the years. So it's kind of an inevitable bond that is being forged because it's like we're fighting together against a common enemy.
Yeah. Okay, so what would you say to somebody who has recently been in an accident but is just super overwhelmed and is afraid that their case might go to trial and just doesn't want to put themselves through it?
Well, that certainly is a personal decision for everybody, and litigation is not for everybody. We do our best to explain the positives and negatives of each decision point, whether that's filing a lawsuit or going to trial, and the client at the end of the day has to be comfortable with it. But what I can tell them is that we do this day in and day out, and these are the cases that we handle all the time. And so they're in good hands knowing that we know how to work the case, we know how to build it up, and we know how to try it. So as long as the client's willing to accept and take our guidance, then although we can't make any guarantees, we can tell them that we have done everything we can to get the best result possible.
That's amazing. Well, thank you for having me today.
You're welcome.
Thanks for listening to Behind the Scenes at Andrew Pickett Law, where we fight for you every step of the way.